In India, what we are facing is that the lack of professional qualified IPR experts. And I think most of the students, they think that it is a profession related to law and only the legal practitioners can. But there is a lot of scope for others also. And most importantly, which can attract the students, and we must guide them for regarding that, it is one of the most highly paid profession. Because most of your clients are corporates, big industries, startups, which have fresh ideas. So most of the students, or even as the young students also, and the professionals also, which are doing their company secretary or CA, they are not aware that what is the scope of IPR and how they can. That is why sometimes most of the companies, which are multinational companies, they are exporting the talent or saving their intellectual property. Now, as earlier they have already discussed what IPR is, what is the idea, so I'll not be taking you much time regarding that, but we'll be confining it to very technical aspect. I've just disclosed that what is the scope, and we must encourage our students, especially the young professionals, to come in the profession, because I think being working in the profession for such a long time, in Delhi I think one big company, law firm, which is doing this, which is into IPR, is one SS Rana, which is experts in this IPR work, and they have a lot of work in that. Earlier, this IPR was industrial property, what we used to call industrial property. Later, the new things come into it, and then it was confined to majorly 4 acts. That was, one was Patent Act 1970, which was, earlier it was pre-independence, it was again there. Then after 50 years, there was change in it. Thereafter, in 1970, the Patent Act was finally formulated. And now, after that, when we signed the international treaties, a lot of amendments have come in it. Now, what the second is Copyright Act. This is one of the best framed law, which has maybe because it was framed in consonance with the international treaties. So it is one of the, most of the time we question how the laws are formulated in India, and we have to get a lot of amendments in it. But Copyright Act is one of the acts which is best framed, and is very, it covers all the international treaties to which India is signatory. Then we have Design Act, then we have Trademark Act. Trademark Act is basically, it is for the protection of a goodwill of the company. What is trademark? There is nothing which is related to which you can gain, or it is just the goodwill which a company or a mark which earns in over a period of time, the reputation, and that is valued. When some company is dissolved or some company is sold, the goodwill, that is the trademark, is valued in terms of money. Now, these were the traditionally 4 acts which were majorly governing the IPR law in India. With the new changes in the IPR, new inventions, and now the few new acts have been framed in it. One is rather geographical indications of goods, like you might have heard about Feni. You might have heard for some Kanjipuram sari, Banarsi sari, or some other trademark with respect to the rice or the food items, Mathura ka peda. So there are, which is related to the geographical area and the reputation which it carries. So that has also been included in the IPR. And one new is that is the plant varieties and the farmers protection. that has been also newly introduced as part of the IPR. So with change of, as India kept on signing the different international conventions, the law started formulating itself and law started making, a legislature made a lot of amendments in different laws. So coming to the technical part, what are the jurisdictions? Because in India you cannot practice as a IPR professional in any state or anywhere in India. India is divided into territorial jurisdictions with respect to the IPR. So majorly there are, it is divided into majorly five territorial jurisdictions. One is Mumbai. People can start practice in Mumbai with respect to the state of Maharashtra, Madhya Pradesh, Chhattisgarh and Goa. So this is one territorial jurisdiction. In these states where some IPR related issues with respect to the infringement or with respect to the grant or procedure for filing is there, that is the territorial jurisdiction is in Mumbai, Gujarat, Rajasthan, Union Territory of Daman and Diu and Dadra and Nagar Haveli, that comes under the Ahmedabad. Kolkata is I think the biggest office of IPR that covers all the northeastern states, Bihar, Odisha, West Bengal, Jharkhand and even Andaman and Nicobar Islands also. New Delhi has J&K, now it is divided into three, Punjab, Haryana, Himachal Pradesh, UP, Uttarakhand, Delhi and Chandigarh. So Chennai covers Andhra Pradesh, Telangana, Kerala, Tamil Nadu, Karnataka, Puducherry and Lakshadweep. So anyone who is interested in pursuing as a profession the IPR, they can think over this, that these are the territorial jurisdiction where they can start their practice or they can pursue it. So this is one. Now one most important, that what these laws, whatever the acts, we will not go into much details because you people are not probably the legal professionals, but what these cover. Maybe it is a patent act, may it be a trademark act, may it be a copyright act, or maybe it be a design act. It involves the definitions, that what are innovations, what are trademarks, what are designs, what are the literary work. So these covers, this is the one part. Second, which all acts cover is the procedure for grant. How can you apply? That I will give you a short overview so that we have little understanding that what is the procedure which is followed. In most of the laws with the little differences, the procedure is common. And then the protection against the infringement. Whatever, if your trademark is registered, after objection, it is the certificate of registration is granted, and then it is infringed. What is the procedure? And in some laws like Copyright and Trademark Act, there are criminal proceedings also, and there is a civil proceedings also. So what are how you people are protected for the infringement? And then fourth part is damages and the penal action which can be taken. So basically all 3 acts or 4 acts, whichever these acts are there, these all acts cover these broader aspects. And now what is the procedure? How somebody can apply for a patent registration or some with the copyright registration. However, for copyright registration, it is not compulsory to get it registered. It is a automatic registration also, but it is preferable if you are pursuing that if infringement happens, it's a proof of, if you have a registration for that, then for your work, then it is the protection that it will be easy for you to pursue legal action against them. So basically, the first is, now the people have started the e-filing portal also. So basically what happened is now, first is filing of the application. When the application is filed, then there is an examination or the scrutiny of the application. Now, one is pre-publication, pre-grant of this certificate or the patent, you have somebody can, if somebody comes to know that you have filed a patent for a particular product, and they can file their objection or opposition to that patent, that I have right on it, or I have, it is not new, it is not a new idea. So sometimes somebody might have heard few years back कि तुलसी और हल्दी का भी पेटेंट फाइल हो रहा है. So there was a lot of hue and cry that अरे ये तो हम लोग बहुत सालों से यूज कर रहे हैं. How somebody can file a patent for it? So this is a similar matter. Somebody can file an opposition. When opposition is filed, you are granted that opportunity of hearing. You give an answer to that opposition. Prior to that also, even when during the scrutiny of the application also, if the office finds that there are shortcomings of your documents in your whatever application you have filed, they will raise the objection. You have to meet that or those objections. That is office objections. And when your application is complete, then there can be a pre-grant opposition by third party. That look, I have a right on this type of a copyright, or I'm giving a common view what happens in all the acts, because it will take a lot of time to explain it all. And then after opposition, when you file a written reply that yes, these oppositions are not maintainable or not sustainable with respect to 1, 2, 3 of these points, and if it is accepted, then the opposition is rejected, and then the examination of your application is done. They will check that whether your application is proper, the search which you have done. Now this part, the chief guest earlier, he was mentioning that it is a very legal process, is very, it's time consuming. This part of the procedure is most complicated and most, which lack transparency. Maybe because we Indians, we are generally still wrapped into that red tapeism. So that is the opportunity, and still we lack experts also. So this is the time where your applications get stuck at the examination stage. Now they have issued guidelines in 2016 for the patent office, especially where they have compiled all the judicial judgments, and those guidelines are based on those judicial judgments to make the system, the examination of your application, more transparent, so that you are aware of what you are your application is being objected, or some hindrance is coming. So that is also helping a lot in increasing the transparency, that how your application is being examined. It's such an interesting topic. However, my personal interest is more into criminal and evidence law. But then also, I find that the young students are not much interested because they are not aware that. But if that is why I requested the faculty also, that make them aware that it is a very good profession for them. They can make a lot of money in it. Instead of going to a company and joining as a management graduate, they should get expertise in IPR, because the corporate has a lot of vacancies in this. They will be easy for them to secure a job, and a good paying job. They can join as agents in IPR agents, also patent agents, trademark agents, and at different levels they have scope. So that is what this was my, and I think as a career also they should pursue it. And regarding the e-filing is that one more important aspect which we lack, and for the infrastructure part also, that is when we are filing a application for patents or trademarks, we have to make extensive search that whether that patent, that innovation is actual. What is the basic criteria for patent is that it should be new and it should be non-obvious. So you need to have a proper system for search. That is a powerful search system to find it out that whether that innovations are actually covered under the new idea, or whether those trademarks are not covered by any other company, and then only you can file the application. So most of the applications are rejected because of this also. And then even if in design also, then you have to find out, the search is the first criteria for filing an application. That whether those, because in all the acts there is definition of what are new products, what are innovations, and if you are not searching it properly, if you don't have infrastructure to that respect, your application is going to be rejected. And that is one of the time that that is one of the reasons that even at the stage of the offices also who are processing these applications, they were having poor infrastructure with respect to search. And now since we are signatory of international agreements, so we need to be very particular in this. 2016 they have enhanced the infrastructure for this also. And one thing more I would like to cover is, I think the examination part, publication also we have covered. Yes. Now, there are two conventions which are very important. You have innovated something and you have, you need to register it whether in one country or you can have registration in multiple countries. So for that, we have India is signatory to at least two international agreements. That is, one is Madrid Protocol, where you have, when you file, you can, with one single application, your trademark is registered in 97 countries. So that is very important, that if you have something, build up some brand in your name with utilizing this protocol, you can get it registered in 97 countries. One problem in trademark which in India we have is, one is trademark and the other is trade name. Now what is trade name is Haldiram, Kapoor and Sons. This is trade name. There is no bar somebody keeping the trade name, same trade name, because that is your surname. But trademark is something sign and some unique thing which is not common to anyone. So trademark you can register, but trade name is something which is still we don't have a concrete law on that. So that is where we are lacking. And rather for other industrial designs also, we have a lot of good scope. And another law which I'm forgetting at that time, where also single application is required to be filed, and you can get that benefit for multiple countries. So this is where. And data protection, one thing now, because this is one more latest shortcoming in the law, we don't have still specific. Earlier there was one bill was proposed in Parliament for data protection, but due to there was multiple objections from all the parties, that has to be pulled back. What we are, which will be covering the communications between you or your data available on the internet, which will include even the privacy part of the of your ideas or your personal data also. So we are still today we are governed by Information Technology Act for the data which is available on internet. It may be innovative, it may be your poetry, it may be your stories. So still we are covered by that. And the second is cybercrime, whatever laws are available under the cybercrime. And one important, because one thing more important which has been introduced is Semiconductor Integrated Circuit Layout Design Act 2000. This is because now I think a lot of people have heard Vedanta has procured has decided to set up a huge factory for semiconductors in Gujarat, which was a bone of contention between Maharashtra and Gujarat also. So for that also, they have drafted a act for, that is for layout designs, that is for protection of layout design integrated circuits. Basically, whatever semiconductors are being prepared in India or even internationally, those circuits or those layouts are also going to be protected under IPR. So that is also now a new act that those are also have been covered now. And rather we are a lot of now, yes, the two acts I mentioned that those have penal consequences also, very important, that is Copyright Act and the Trademark Act. And even the police has been given a lot of powers with respect to the copyright and trademark, because we are exporting somewhere, making after China the duplicate products of all international brands and even Indian brands also. So for that also there is punishment from 6 months to 2 years in one act, and for 3 years, up to 3 years in another act. So they have penal consequences also, criminal proceedings can be used. However, when the infringement, just the chief guest mentioned that why people don't want to pursue if some poetry or some literary work is stolen, because the damages which are offered are very less in amount. So nobody is interested to face a lengthy procedure and then get some merge amount for that. So that is one of the reasons. And the patents are granted for a time period like 20 years, and then trademark is granted for 10 years. Now that consistency has been maintained after the amendments, and then it is renewable. Sometimes for Design Act, under Design Act it is for 5 years with payment of fees, and for the Trademark Act it is for indefinite period, that is with 10 years renewal cycle. So since TRIPS they have covered, the chief guest also has followed that. One important debate which is going on in this IPR is with respect to pharmaceuticals. Pharmaceuticals as well as with respect to your foods. So pharmaceutical is for IPR in pharmaceutical sector. It is still a big debate, because most of with respect to, especially with respect to the life-saving drugs and drugs which are otherwise generic in nature, and India is the largest manufacturer of this generic drugs also. So with respect to that, that is also a lot of debates are going on, that whether to what extent this should be applicable in pharmaceutical sector. However, the process is patent. You can get the process of manufacturing of some medicines and the food that can be certified or registered, but that drug or life-saving drugs have a time limit for that patent or the whatever the outcome is there. That is patentable for only for particular time. Thereafter, that is made open for all the companies who want to pursue, and especially with the life-saving drugs, they are not extendable to a large extent. However, since still the world community is divided onto this aspect, because the pharmaceutical sector is again a very powerful community which is not interested that it should come out of the this IPR. Now regarding the, we have been all now more aware about the farmers' rights after this farmer agitation. So the Protection of Plant Varieties and Farmers Act 2001 has been also introduced, which popularly is known as Plant Act, and that has encouraged to form an authority at international level for protection of new varieties of plants, and it is the farmers' right. So Indian government has till date registered about 114 plant varieties to be its original, and they are still pursuing the more plant varieties to be registered under the Plants Act also. So this is again a very important with the this act, the farmers will be able to secure good quality of seeds, and agriculture sector of our country will have a great advantage because of this act also. And now, which is the, we have now gone through such a whole set of framework. What is the, which is the department under which the IPR comes? it is under Ministry of Trade and Commerce or Commerce and Industry, but the particular department is Department of Industrial Property and Promotion, that is DIPP. This is the main department under which the whole patent work, trademark, and this is the department which regularly conducts seminars, knowledge enhancements for students, professionals, and they conduct a lot of online material sessions also. And the authority which is competent authority under which this is covered is regulatory authorities, Controller General of Patents, Design and Trademark, and that is under the Department of Industrial Policy and Promotion. And the police, the powers which has been granted to police, because we in India, since the people are not much aware of the IPRs, so infringement of IPR is maximum in India. So to overcome that, a lot of powers have been given to the police also, that it can even go and search and seize without warrant. But there is one drawback which is delaying, or which cause again infringement of the rights, and the prosecution is not able to take the infringement to a conclusive end. Because when the police gains the knowledge, it can make, but it has to seek the opinion of the registrar on the registration of mark, that whether it is actually original. After seeking opinion of the registrar, then only it can go and search and seize and take punitive action. So police has been given powers, but with the writer. So that is why still, even that after grant of so much powers to the police for protection of IPR rights, still the police it's a toothless institution or organization. However, misuse is also quite visible in some flow charts regarding the copyright or this patent registration flow charts, which may be helpful for them if they are studying that. They can take it. I'll hand it over to some faculty member. Encourage them to come and join the profession as an IPR professional. It is not, irrespective of, it is not compulsory for everyone to have a legal degree for coming to the profession. If the company secretary's course is also sufficient, and you can join without pursuing the legal degree also. Thank you so much.